All right, then we have the defendant's motion for no restraints in trial dated May 6th. I don't know.
So this is no restraints. So not what she had last trial. She wants even less. It's like you've just been convicted of another heinous and violent crime, or at least a conspiracy to commit that crime, and you want less restraints. Now, she may have a point that no problems in that trial, so why do we really need restraints? But they ain't going to go for that.
In your motion, I don't know where you get the idea that the sheriff's office recommendation ever was that you have no restraints at all. Their minimum recommendation was that you wear a rack belt.
Well, I have it right here and I copied it verbatim.
Yeah, you said what it said was my recommended minimum requirements as listed above, and those were to wear a rack belt.
It said, or the recommendation of MCSO was that they could have a unarmed detention officer and an armed deputy sheriff if I was to not have any restraints.
Right, but that wasn't their recommendation. I received the defense motion. I received non-party Maricopa County Sheriff Jerry Sheridan's response.
On the MCSO security justifications, my understanding is that was his recommendation.
Your Honor, Joseph Vigil for the Sheriff's Office, if you have a question.
Oh, okay. Well, I'll deny the motion from the defendant. The same conditions will be set that we had in the first trial, that being you wear the rack
They're like, we have somebody from the sheriff's office. He's like, no need, denied.
belt, no leg brace. There was one incident during the trial where you asked to take a break because a strap was hanging down behind your jacket. We did that. We rectified the situation. There's been no indication whatsoever that the jury noticed the rack belt or anything like that. So I think those conditions are appropriate and will remain for the second trial.
Your Honor, the jury was not polled to see if they noticed anything either. Was that correct?
Right. There was no request for that. All right.
So she's like, I guess there was a part in the other trial where a part of the restraints were seen. He's like, well, the jury didn't care. She's like, well, nobody asked. He's like, well, nobody asked us to ask. She's technically right that he's assuming nobody saw it, but we don't actually know that. If it did come to her attention that something was revealed in trial, maybe you should have asked the jury about that. But again, how big of a deal is that? I don't know.
Okay, so next we have defendant's motion to consult with advisory council and team during trial dated May 6th. I don't know.
I mean, it's a fair request. Like, she wants to be able to consult more with her advisory council during trial than she was the first time.
I guess what exactly are you requesting? Are you requesting that during the lunch recesses you be housed somewhere where you can meet with your team?
Correct.
Okay.
And I know that it's a DO situation, and I know that our DO has his other obligations to do. So I didn't know if another officer could if something could be arranged so that I would have time with my team during those breaks and during lunchtime.
We did accommodate that during breaks and recesses during the trial to the extent that it doesn't delay the jury getting into the courtroom and resuming the trial when we need to, like when we take the 15-minute afternoon recess. That will continue. You'll have an opportunity to meet with them briefly. Over the lunch hour, I think is the real question. I did receive a response this morning from the sheriff's office, which indicates they don't really have an objection to that. Is that correct?
That's correct, Your Honor. There is an area on the fourth floor in the South Court Tower where she can be taken to meet with her advisory council, and they'll work that out.
All right. I don't have a problem with that. So if you need to meet with them when we break for lunch, just indicate to the DO that's what you need to do. There may be a day where you don't need to meet with them, but I'll essentially grant. Ms. Kay, I don't assume you don't have an issue with that.
I have no position on it.
So I'll grant the defendant's motion on that she can meet during the lunch hour. Again, the only restriction on that is that we're not going to delay bringing in the jury at 1:30. We'll expect everyone back in the courtroom to start on time.
So he's saying no problem with that, but it's not going to delay the trial. So she's not going to be able to meet with them for hours and hours and say, well, I didn't have time to go through all that with advisory council.
Just received the defendant's 15.2 that lists 2 different expert witnesses. I did request that they actually comply with Rule 15.2 and give me any information about any of these experts. They've also listed other witnesses. So because of that, I would still screen them for the other week.
Well, maybe we should address that. Is there still no report from Lonnie Dworkin that the state's received?
I've received nothing.
Right. Do you have some sort of expert report you were disclosing?
We will, Your Honor, yes.
When?
Well, when is that going to be? Because it's way past due.
So once again, she is still trying to get witnesses and evidence in, even though she is way past the deadlines. It's unbelievable that she doesn't understand that by forcing a speedy trial, she has to get things done ahead of time, representing herself. Every decision she has made has created an absolutely impossible vortex where she is just not going to be able to get everything done that she needs to or wants to.
So we The state did receive the affidavit from Lonnie explaining the things, which is why they turned over late discovery in the middle of trial. So we did have that. He's working on a few things for us as well now, and I will get with him as soon as possible and get that report to you as soon as possible.
All right, well, it's, depending on what's in that report, it is likely to be precluded at this point, but I'll keep an open mind on that, and I guess we'll wait and see. Let's talk about, for the purposes of scheduling,
Your Honor, and just, there's one other person that I
I'm-
Googled.
I'm going to ask her about the other
Okay.
witnesses. I received your supplemental witness list, I think yesterday. You have, in addition to Mr. Dorkin, you have Weaver, Barkman, again, Detective Moffett, Jeffrey White, Melanie Gibb, and Zulema Pastanas.
Zulema Pastanas.
Okay.
Mhm.
Was Detective Moffett also involved in this case?
He was involved with the case agent of this case while he was the case agent of the other case, correct?
So he may or may not have, he may have relevant information. Again, I guess that's a wait and see. What about, who's Weaver Barkman?
So he's a ballistics expert?
Is that an expert? So that's an expert. Do you have an expert report that's been disclosed?
Not yet, Your Honor. We're working on it.
Your Honor, since I have not noticed a ballistics expert, that's a big problem, because if I get something, then I would have to do that. So the defendant's, again, extremely late violation of all rules of criminal procedure is a problem.
It is a problem. Who's Jeffrey White?
My investigator.
Oh, okay. And do you have an idea of in what capacity you think he would be called?
Well, we had made a request from the state for the car door and the window that the bullet supposedly hit, and we were going to have him inspect that as well. We have recently found out that those two things do not exist. So
So
I'm not sure what they're going to be putting up as far as ballistics in their case in chief. So I was trying to have someone who could be able to look at whatever reports they're trying to put up and rebut anything that they're saying.
Is Mr. White an expert in that area?
Mr. Weaver?
No, I said Jeffrey.
So their wires get crossed here. He was asking about her investigator. She was talking about the ballistics expert that she hired, but that just was a misunderstanding between the two. Oh, you mean that doctor's doing interviews? No, pass. I'm gonna take a hard pass on that one.
Jeffrey White.
He's my investigator.
Right, that's who I was asking, who has relevant information. What's Mr. White's relevant information for, why might he be called as into trial?
Because he's interviewing the witnesses as well, the defense witnesses.
So is it some sort of extrinsic impeachment if they,
Correct.
what about Melanie Gibb?
So Melanie Gibb and Zelina Pastinas were both initially noticed in the state's 15.1. They have not noticed them again. I don't know if they can still call them if they're on their list, but
Have you,
they have relevant information to this case.
have they been presented for an interview by the state?
They've both been interviewed multiple times by the
I
state.
mean, not by police officers, I mean by either a prosecutor or someone in her office for, in preparation for trial.
In this case,
In either case,
not that I'm aware of.
have they been subpoenaed?
The subpoenas are out.
That's a no.
What relevant information would they have?
They have relevant information to Brandon Boudreaux.
Okay.
And around that
What
time,
is the nature of that relevant information?
it will come apparent if they have to get up and testify, Your Honor. I will only call them if I
Well,
need
they're going to
them.
be precluded if you can't give me some minimal, what relevant information they have. Just saying that they're relevant doesn't make them relevant. Okay,
Yes, and there's this procedure that I have to say what each of my witnesses are relevant ahead of time and give my whole case in chief over to the state. It is?
So she literally doesn't understand. I mean, we shouldn't be surprised, right? But this is where she starts to get angry. This is where she starts to literally go off on this judge, and he's had about enough, especially because everything she's doing is literally breaking every rule that there is. That's what she's doing. Any lawyer does this. He would be like, Mr. Tragos, you know that witness ain't getting in. You know you're not going to get that expert. You know you're not going to get that evidence, and you didn't turn it over. Trial's in a week. What do you think? You think the rules don't matter? That's what he would say. Have they been subpoenaed? Oh, the subpoenas are out. It's like, that's a no. So come on. And what is their relevance anyways? Well, I don't want to have to tell you every single thing every witness is going to say. It's like, we're not asking for your defense strategy. We're not asking for everything to say. Just tell us generally why it's relevant. And if it's because the bullet doesn't match the gun, or if it's because he's going to say that that officer lied, or he's going to say that witness lied, or that witness had something against me or is biased against me. You just generally say what is relevant about that witness. You don't have to talk about your entire strategy and give it all away right now. That's not what he's asking for, but she doesn't know the difference. That's the point. And now is where she's going to start to get frustrated with the fact that she doesn't know really what's going on.
Yeah.
That's
just
how
like-
it works.
like
That's the
this.
rules of law.
Stop interrupting me. Yes,
Mhm.
that is the rule of law. That's just what the state does. They tell you what relevant information each witness has.
Stop interrupting me. That is the law. The state has had to say what the relevance of every witness they're calling is. We don't just let them call the Queen of England. They got to call somebody that actually is relevant.
So my answer is yes. So if you can't tell me what relevant information they have, they'll be precluded.
They both have had dealings with Brandon Boudreaux and Alex Cox. So
Okay, so does someone, that was a server for them at a restaurant. It doesn't make them have relevant information as to this case. Anyone who came into contact,
He's like, yeah, their third grade teacher knows who they are too. She can't testify at your trial. That doesn't make it relevant. Explain to us how it makes it relevant.
with Mr. Boudreau or Mr. Cox, had some interaction with them at some point in their lifetime does not make them a relevant witness. So what is their relevance?
the state had them on their witness list and you're saying they're not relevant?
Apparently not. Are you calling them?
No, they're not on my,
Police interview however many people they interview because they're working on the case. They don't know who has relevant information, who doesn't have relevant information. All the people that they interview don't end up being relevant. So because they're listed in a police report somewhere, doesn't necessarily make them relevant.
Okay, their relevance lies.
Elizabeth, I agree. I think some of these people she's talking about could be relevant. She has to still serve them on time and give the state the opportunity to interview them. You have to still play by the rules. But when the judge asks, you have to be able to articulate and explain to the judge how they're relevant. Sounds like you can, Elizabeth N. I'm sure I could if we talked about what these witnesses one by one, but can Lori Vallow? She has made the decision to put herself in the chair to answer these questions. Lazy L, does she have a different advisory council for this one? I don't know. I don't think so. If this is about the next trial, if so, why wouldn't it be the same person? I think it is the same person. I think it is. But when she's going, when the Friday night lights are on and it's game time, it's not practice anymore. We're not talking about practice. She's got to be able to answer these questions herself. And if she can't, the judge has to make the decision with the arguments and facts that he has in front of him. He's not going to make all the arguments of why these people are relevant. She has to.
Guys, and if they have to rebut something that the state puts on in their case in chief. They're just called in case they need them. They're subpoenaed in case I need them.
All right. It sounds like they don't have relevant information. However, I'll include these names on the potential witness list for screening the jurors if the jurors have any knowledge of any of these witnesses out of an abundance of caution.
He's like, just in case, when we read the jurors, do you know any of these people? Have you heard of any of these people? Would any of these people cause you to not be a good juror on this case? I'll read their names. I'll read their names just in case. And that's a smart judge. That's a judge looking ahead being like, I don't want these problems. So, God forbid something happens. She does explain why they're relevant. They do get on the witness list. Then fine, we'll read their names just so we don't have any jurors that are cousins with these people, friends with these people, work for these people. Fine, we'll do it that way.
That's really the purposes for today is the questionnaire that goes out to the jurors. So I will include these witnesses. Again, Mr. Dworkin, Mr. Barkman, if they're expert witnesses that haven't provided any sort of report or expert witness testimony, they're likely to be precluded as witnesses. But I'll include them on the witness list. I think what I'm hearing is you said you might finish on the 9th or the 10th?
And what he's not saying is Lori Vallow called, let's count them, 0 witnesses last trial. The defense's case in chief in the last trial took 0 days. So he's like, if you're going to finish on the 8th or the 9th, we might just be done and doing closing arguments. So that's what he's trying to do. He's just trying to plan ahead. And he's trying to tell the jury, because I'll tell you what else. It's a lot easier to pick a jury for a 2-week trial than it is for a 1-month trial. the longer a trial is, the harder it is to pick a jury. So he wants to know what to tell the jury. And he's, when you don't know, especially a pro se defendant, that can really affect the schedule and how long it takes. I mean, from my perspective, he's trying to do his job, as difficult as Lori Vallow is making it. And she's going to continue down that road here the last third of this hearing.
I'm going to indicate on the questionnaire to the jurors, potential jurors, that the trial is likely to end by June 13th, Friday, June 13th. However, I'll include that Monday, the 23rd, and kind of say, if needed or if required, might go to June 23rd out of an abundance of caution.
So he's still going to give it time just in case that Lori Vallow can't say, you cut this trial short. You shouldn't have. You didn't give me the opportunity to present my case. And that's the smart thing to do, even though it is probably going to be more difficult to find a jury.
So I'll finalize that questionnaire. It's pretty much done, and it's pretty much the same as the last one, except for the names of the witnesses, the specific allegations. And then I removed the question about viewing medical examiner autopsy type photos because that's not needed in this case. But I'll send you guys out a copy. Actually, I could probably finish it in the next couple of minutes and print out a copy so you have it before you leave here today. That questionnaire, I need to get with the jury office. I think we were talking about sending it out the 22nd and cutting it off the 28th or 27th. And then we'll meet again on the 29th in this courtroom to go over the responses. That'll be at 1 p.m. on the 29th.